special guest today, Miss Iram Majid, who is the Director, Indian Institute of Arbitration and Mediation, and she is also an IIMI certified mediator. And I would like to invite our first speaker, Madam Iram Majid, to enlighten us about her views relating to role of mediation in family matters.
Thank you so much, Justice Sanjay, Justice Anjali, Uma ma'am, Pramila, and Mr. Ashutosh for inviting me especially. So thank you everyone for inviting me, since it is a very good topic. So as Kiran, you have mentioned rightly that these are the disputes which are highly emotionally charged disputes. So I would like to say that the scope of mediation, if we see in India, is very, very promising, and for bringing up inequitable treatment in a sense of fairness and justice in the society. Mediating skills, especially unbiased communication skills and influential bargaining strategies, are to be engaged. Conflicts cannot be averted, it can be resolved, and conflict can be turned into an opportunity. But every relationship goes its ups and downs, and especially in matrimonial disputes, there are a lot of ups and downs, because in this session, we are discussing about the role of mediation in family matters and matrimonial matters. So I'll be telling you I will be highlighting the benefits of mediation in these kind of disputes, and then I'll be discussing one or two my experience in my mediation, where I have done 2 cases which are highly emotionally charged mediations, and then certain recommendations and suggestions for the panelists and others to look into it and to bring a roadmap regarding the such kind of disputes. So as I told you that every relationship goes its ups and downs, and if you talk about divorce or reconciliation, see, these both are very, very personal and common phenomenon globally. Either it is reconciliation or separation, mediation plays very, very important role. If parties are going for divorce, and then it can be analyzed as a decision to leave the partnership and end the marriage. So, however, they can be preceded by a long process of ending the relationship. There may be a lot of other things which can be, subsequently some other disputes may be attached to one main disputes, and which can include estrangement from the spouse, stress, conflict, and even violence can be involved. So such disputes involve high emotions, other spirals, along with other connected matters. So according to Robert Ware, behavioral disorder in children of estranged marriage face difficulties in dealing with the opposite sex and suffer poor academic performance, are often in the long-term nature, which can be a disaster, which lead to family if we will not able to handle these disputes timely and in litigation, if we are taking this dispute in litigation. So we can counter all these aspects if matter will go for mediation. So if one dispute, like you can say a divorce petition or divorce dispute, or the family matter or the matrimonial dispute, so the kind of other disputes attached to it may be that the parties want to go for the decree of the nullity of a marriage, or declaration of the validity of the marriage, or the status in the matrimonial status of any person, suit for proceeding between the parties to a marriage concerning properties of the parties or either of them, suit of property declaring proceeding or the declaration of legitimacy of any person, or the suit proceeding for maintenance, guardianship, custody, access to minor, all these things. See, all these are connecting disputes which one disputes, and if you see, if you able to settle one dispute, you will be able to settle all these disputes, all these issues in one go. So mediation will decrease the burden of the court. We only calculate that one case has been decided, but one case has been settled. No, it is not one case always. When it talks about matrimonial disputes, it always a bundle of cases, bundle of disputes, bundle of emotions which we settled in one go. That is called in matrimonial disputes. See, all disputes are very, very closely connected. And technically in mediation, as I told you, 4 or 5 disputes we can settle in one go. Now, if we talk about the pre-litigation mediation is the way forward in this regime. As we know, at the case Srinivasan Rao, where the Supreme Court discussed the idea pre-litigation mediation in the context of family disputes. court acknowledged that a dispute arises due to trivial reasons that are solved by pursuing litigation. It was also observed that the data, the data from the Delhi District Court shows that chances of successful resolution are higher when the party approach to mediation at earliest instance, not wasting the time in the court and then you will be going for the mediation. Then it may take a lot of years and years. So pre-litigation mediation is a way forward in this regime for the mediation. And even if you see that the B.S. Krishna Murthy case, in this Justice Markanda Karju held that the lawyer should advise their clients for mediation, especially when the dispute is family in nature. Otherwise, the litigation will go on for year and year, decades and decades, which will be detrimental for both the parties. So these are the benefits which in one go you can resolve all these disputes and all. And but these benefits can be accrued to you, and you can be able to get the fruit of this mediation in the family disputes only when the mediators are trained to handle the emotions well, because these disputes are highly charged emotions, and just a basic training, after acquiring a basic training, it may not be possible for you to handle the emotions effectively. Because if you take the commercial disputes in one hand and matrimonial disputes in one hand, skills are required for that, but emotional handling of emotions and treat parties with empathy is something which you need to learn, and you need to have extra edge on that. And because these dispute required certain special skill set to handle. I can share you one of my case when I was doing mediation in Delhi High Court. So there was a dispute where both the party, they were having a partnership. And this case was having two aspects, commercial aspect also and relationship aspect also. So they were having a partnership. They both were partner in one business, and they fall in love and they performed marriage. After this marriage, the girl was from different faith and boy was from different faith. They converted into one faith and they performed marriage. After that, they had a baby. After baby, 3 of them converted into another religion, the religion of one's spouse. After some years, the husband converted back to another religion. See, this was a change of religion for one religion to other religion, another religion to other religion. And then that dispute came before me, that how to resolve this dispute, what would be the religion of the child, and how the child will be brought up, what would be the custody of this child, how the business business issue can be resolved between these two parties. See, I get a goosebump when I tell you about this case, because that case has 2 aspects. One is commercial and one is relationship. When we talk about the commercial, it was very, very easy to resolve, just 50-50% of the, they said, okay, 50-50%, we are happy to have that. But when it comes to emotions, it required special skills. It required, to treat the parties with empathy, with compassion, and use different set of skills, some sort of, you may say, hypnotic languages or metamodal set and all. So it required a different altogether skills. In one case, I learned a lot. And then the outcome was so miraculous, so miraculous that no court can come up to that outcome. And with this, I learned a lot, and I come to know that, look, same party having the same perception, same mindset, but the outcome for the two, and when they were on the 2 different aspects, one is commercial and one is relationship issues, they were completely different person, altogether completely different person. When they were dealing commercial, they were completely different person, and when they were dealing emotions, they were completely different persons. And there the role of mediator is very, very important, because you have to be the navigator. You have to be the navigator of their emotions. If at one instance you are unable to handle their emotions well, you may lead to disaster of the parties. We know that we have mediations. We know we have mediation cells. We have institutions and all. But what is the most required thing is, in this kind of situation, that we need to have more skilled mediator. And one thing also, I would like to tell you one example. See, recently in the COVID days, when I got COVID, so one person used to visit my place for all the tests and all. He was very, during that days, he become a family member, because every other day, all the family member were into the COVID. So he used to come for having our test without any, inhibition and all. So recently I called him, and he called me and he said that I'm having some matrimonial issues, and I'm going for mediation. I suggested him that should go for mediation because he had 2 years old child. So don't, immediately go for case and all. So go for mediation. But somehow because of my traveling and all, I could not assist him in the mediation. But last week only he came again to have my one test, and I saw, you will not believe, I saw he wrapped what you called a handkerchief around his neck. But somehow that handkerchief, got displaced when he was talking to me, and I could see a very big mark on his neck. I said, what is this? And he said, there was a fight and my wife has strangulated me with this. I said, but you went for the mediation. He said, yeah, I went for the mediation, but it was not successful. I said, why? Because the mediator was unable to understand the underlying interest. They were unable to understand underlying interest. I keep on saying they did not believe, and situation become more worse when we came out from the room. So that's what I would like to say, that we need to have a special skill set to understand the emotion of the parties. We cannot miss out on any emotion in this matter. And if I say to all of you that there was a survey conducted in New York, they said, okay, suppose if there are, you have to scale on 5% that how much negative you need to stay in a matrimonial, tie-up, or how much positive you need. So there was a different answer. The US result, I will not tell you. First, I will tell you that what in India, they said that, okay, if there is on 5, if there is 4 negative and 1 positive in a matrimonial thing, I will be able to stay with my husband. And I asked other, this different generation people, they said 2 to 3, this will be the ratio. And then the result in the US was, you will be amazed to know the ratio with the negative and positive in a matrimonial tie-up, that was 1:1. And that's where we are lacking, 1:1. If 1 positive, then 1 negative. It should not be in the sequence, but yes, that much of appreciation the parties required from their opposite spouse. And that was we are lacking. We are not giving that 1:1, but we are happy in 4:1 also. And that is what we are doing. We are dragging dead bodies, relations of these dead bodies on our head every day. And we are dealing in mediation with those dead relationships where we have 4:1, positive, 4 negative, and 1 positive. See, that's what I say. And that we don't understand that what the parties are going through, how emotionally they are charged, what is there in their psychology. Some people are committing suicide if they are not going through with the mediation. So we need to have skills to understand that what is the orientation of the parties, 4:1 or 1:1. And we have to give that to the parties by understanding their underlying interest, what is going in their subconscious, what is there in their mind. So we have to find out that. We have to go deep down and beyond the conscious mind. We have to enter into the subconscious mind to take out the structure of the conflict and bring it on the table and show it to the people. That's what we need. And for that, 40 hours training, as everybody said, not possible, not enough to say. And if I have been in the Hong Kong and other places, they are providing, the ministries of justice in those countries, they are providing different trainings. If suppose investor state mediation, different training, cross culture, different training, handling emotions and mediations, different training. So what I urge, because we have 3 eminent judges, and who can change in their mediation center, this thing, just not 40 hours training. I urge all of you that please, we need 3 more days training to handling emotions, how to understand that, and how to serve this community more on a different level. This is what I urge. We need to integrate NLP. We need to integrate how to understand the language, hypnotic language, meta models, and different aspects. So we need to revise the curriculum. We need to add on more for these disputes. And I hope that this panel discussion should create a roadmap for the matrimonial disputes, how to handle that. And we could generate some good curriculum also. We can add on some trainings into this by the court and its mediation. Thank you so much. This is what's from my side.
Thank you so much, ma'am, for your inputs based on your own professional experiences, acquainting us with the harsh realities of mediation.